Hello, Anita.
Hi.
Welcome to class. I'm just getting my screens all situated here.
No worries.
Thank you. Can you see, what do you see, Anita? Tell me what you see.
I see the required student materials section.
Fantastic. All right, perfect. We're all on the same screen. Okay, hi, Seppi here. All right, let me start with attendance. Okay, I know we're just getting started, but it looks as though we're in week 8, and I'm going to start um, taking some attendance. So we've got Paula, we've got Seppi here, we've got Anita. And I expect others will slowly trickle in as happens, right? So let's see here. Anita, Paula, and Seppi here. Mark you guys as present. All right, it is 6:02, so I don't want to wait too long. And I know as people trickle in, they will join and we can catch up. I'll catch up on the class attendance. Um, I have a lot of things to cover. We have a lot of things to cover today. I would say more than perhaps even usual, particularly because of the upcoming midterm. And we have not yet taken a midterm in this class yet. And for those reasons, I want to make sure that I give you good instructions on the midterm and make sure that I go over the topics, give you some guidance, help you to focus, help you to build a strategy and approach on how to be successful and how to do well. So that is something that I would like to do with all of you today. So this is how the course, or not the course, but this is how today's class will be divided. The first half, we will review chapter 8, and we will continue with our discussion about internet research, um, different types of research sources, to do case law research and statutory research. So we'll start with reviewing chapter 8, as we normally do. We will do the case studies together as a class. I find that that is really good. It's a good exercise not only to help you understand the course material, but also to know how you'll be tested, in the midterms and in the final exams, because those are good questions. They're good questions that help you determine if you've picked up the big lessons of the chapter and if you understand the nuances also. So I want to continue to work through the case law, excuse me, the case studies. And then once we've finished reviewing chapter 8, we've gone over the case studies, then I want to go into midterm prep and talk about all the details, take questions, and go through how you should prepare for that. Before I do that, the other point I wanted to share with you was the breakdown in terms of the weight. Um, we have 5 different components that together will compromise your grade. Homework counts for 10% of your final grade. Quizzes count for 20% of your final grade. The weekly projects, which everyone has been turning in, represent, you'll see the highest point value goes to the weekly projects. And the reason for that is because you are taking the theory that we learn about from the book and from class, and you're applying that theory into practical assignments in the weekly projects. And those practical assignments should mirror the types of work you receive in your co-op. And so that is why the weekly projects are worth 40% of your grade. After the weekly projects, the next category would be the tests, which include the midterm and the final exam. Those are worth 20% of your final grade. So look at the difference in terms of, what has the highest weight. It's the weekly projects. And then 10% of your grade will come from your attendance and your participation, which, I have to say, everyone has been doing fantastic on that. I'm really helpful, or I'm really grateful to all of you, because that's what makes a successful course, is the interaction between myself and all of you. So I think this is pretty self-explanatory, but I thought it would be good to look at this. So going in, where your midterm, rests in terms of weight, and then where do the projects lie in terms of weight, and what is it that's getting contributing the most to your overall grade. So keep that in mind. I'm pulling this from our syllabus, and we can always revisit that if students have questions later on. But from there, just to give us some perspective in terms of where we are in our 15-week course, we are roughly halfway through, right? Week 8 and 8 is 16, and we're a 15-week class, so we're a tiny bit over half, which I think is fantastic. So today we will refresh a little bit from chapter 4, which is case law, research, and briefing. We'll talk about chapter 8, which is titled Commercial Internet Research. As you guys will recall, last week we spoke about non-fee-based research, i.e. free online research. We talked about the pros and cons of that resource, and today we'll continue with commercial internet research. And once we're done with that, we'll go into midterm prep. So without further ado, let me go ahead and log into chapter 8 and pull up the case studies. Before I do that, are there any housekeeping concerns that any of my students may have? Admin type stuff, are you guys getting your pumpkin spice lattes? Is that out yet? I mean, are you guys on that? I have a cup of coffee here in front of me because it's a little chilly in my office today, and it hasn't been that when I'm wearing a sweater. So that's like kind of, to me, that signifies fall. So if you guys are feeling the same, we can put our sweaters on together and get our warm drinks. So let me go ahead, and on a separate screen that you cannot see, I'm going to, first of all, let me update Kate's attendance. I'm going to go ahead and add Kate is present.
I have a
Oh,
question
and
about the
yeah, go ahead.
midterm. I'm sorry.
No, don't
Um,
apologize. Go ahead.
so I will be going out of town this weekend. Going on a cruise this weekend,
Okay.
and um, I want to know, does the exam like open on Sunday,
No, it
or
is open now.
we
It
have
is
time
open
like this
now.
Sunday
You
to
can
take it?
take it at
It
any
is up.
point,
Okay.
but it closes Sunday. It closes Sunday at
Okay.
11:59 p.m. Yep. But it's open now. So you have all week to take it. And I'll go over the details of that.
Okay. I just wanted to where I had time.
Yeah, you've got time. You've got time. And I'll go over the details of the
Okay.
midterm once we get to that. But that's a great question. So if you feel like
Okay.
taking it today, you're
Thank
welcome to take it today. If you want to take it at any point this week, you're welcome to. Just know that the door closes on Sunday at 11:59 p.m. So it's got to be done by then. So keep that in mind, and we'll talk about all of that
Okay.
in a brief second. So
Okay. Thank you.
you're welcome. It's a great question. All right, now I'm going to pull up week 8. We're going to go straight into the case studies. Of course, I'm in chapter 8. All right, let me pull this over so you guys can see. All right. So chapter 8, as I open up my book, is entitled Commercial Internet Research. So we're continuing our conversation about how to do research online. What are some of the different resources that you may have available to you to do legal research online? And this is a really interesting setup here. So let me go ahead and read the facts to you. And then I'll call on my student on the top left-hand side. And I think that right now that's going to be Seppi here. So we'll start here. Let me just grab my notes real quick for chapter 8. All right. So here are a set of facts. Mrs. Vanderplatz was pleased with her decision to give up wearing her fox fur coat and switching to wearing a faux fur jacket of such high quality that it was hard to distinguish the faux from the fox. She debuted her faux fur jacket on opening night at the opera. Just when she was descending the steps from the opera house, and with every eye upon her, a young man ran up to her and threw an entire can of red paint all over her jacket. He, like others, was fooled by the faux fur. Mrs. Vanderplatz was horrified and embarrassed. The young man was caught and arrested for assault. Mrs. Vanderplatz is suing him for the damage to her faux fur jacket and the mental suffering caused by the embarrassment. Allison is a paralegal who works for the firm representing Mrs. Vanderplatz. Allison has been asked to research the issue of mental suffering. So keeping in mind, there are two actions here that the firm has been asked to look into. One is assault, and we're not going to focus on that particular cause of action. The second is the mental suffering, and we often refer to that as IIED. I don't know if you guys have come across that acronym yet, but it stands for intentional infliction of emotional distress. But it's essentially mental suffering. So Allison has been asked to research this issue. Her law firm subscribes to Westlaw, so she's able to do her research online. Now, Westlaw, as you guys may have picked up by now, is one of those internet research sites where your law firm pays a fee for, and then you, if you work for the law firm, can get access to it. And it's a fairly comprehensive search engine or search tool. And people rely on it quite often. It has a few competitors. We'll talk about those. But for this particular set of facts and for question number 1, we're going to start with Westlaw. So Seppi here, you are going to help Allison answer this question. Allison would start her computer search using which of the 4 below, keeping in mind, number 1, she is a paralegal at a law firm. Number 2, the law firm subscribes to Westlaw. So the question is, where would she start her computer search? Will it be using A, keywords? We'll skip B for a moment. C, case names. D, case numbers, or all of the above. So, and I'll walk you through this, Seppi, here, and I'll probably ask you some follow-up questions. So let me first get your initial response. Where do you think Allison will start her computer search?
I think she would start from keywords like emotional distress or what was the other one? Mental suffering.
Mental suffering. Okay. And why do you think keywords are something that she would use, given that Westlaw is her search engine? Why would that help her do her legal research?
To find best law for her case and best information about
Yeah.
her.
And to help her focus her search, right? We want to narrow her search. And then the keywords, what they do is instead of looking at the entire universe of legal cases in the US, you can focus on the ones with the key terminology. So let's take a look and see if you are correct. And you are correct. So keywords are exactly where Allison would start to do her computer search. And I like the keywords that you suggested, Seppi, here. Mental suffering, right? It can be mental suffering following an assault. You can even put those two together, assault and mental suffering. But here they've been asked to focus on the issue of mental suffering. So you can put in mental suffering. You can put in, if you are familiar with IIED, which is intentional infliction of emotional distress, you can put that in too, and you can see what comes up. So that's a great place to first start. And you wouldn't really know enough to put in a case name or know enough to put in a case number at the very early stages of your research is what I would think, because you haven't gotten that far yet. You're really just starting out. It's day one. You don't have a case name, so that means C obviously cannot be correct. You don't have a case number yet, so D cannot be correct. And if C and D aren't correct, well, then all of the above can't be correct. So using process of elimination keywords makes the most logical sense, and it is factually correct. So well done, Seppi here. We'll go on to our next case study question. And I'll call on Kate because you are next on my list here, Kate. So using Westlaw, Allison will be able to conduct a natural language search, true or false. So before I actually ask you to answer true or false, Kate, do you know what is a natural language search?
I don't believe so.
Okay. Well, you know what? That's an excellent time to ask our friends. Class, does anyone know what a natural language search is when you're doing legal research? And if I see Paula. Okay, Paula, go ahead and let us know.
I'm going to take a guess, but I think
Yeah.
it's just an English search.
That's exactly it. So you type in the search the way you would speak to someone and ask them a question. So if I don't know a whole lot about mental suffering, let's assume you just go to your Google search bar. What are you going to type in? What are the elements for mental suffering? Or what is the legal, give me a legal analysis of mental suffering. You talk it out, but you use words. So a natural language search doesn't require any special terms or connectors. We're going to talk about that in a little bit. So the one option, the natural language search, is what this question is asking about. The other option would be what we call terms and connectors. And that's where you put it's where you use keywords, but you put them in like quotes. And sometimes you put an and in between, in the middle. Sometimes you can use different parts of your keyboard to help narrow your search. And we'll talk about that in a little bit. But natural language search is exactly what it sounds. It's like using natural speech. And you just type it into Westlaw. Westlaw is smart enough that it can take your question formatted as if you were just asking a question on Google, and it'll translate that question and help you find the correct legal research. So knowing that, Kate, using Westlaw, Allison will be able to conduct a natural language search, true or false?
True.
True. That does stand to follow, right? If that's what natural language search, if that is what that is, then it would make sense for her to go ahead and start there. And that is correct. So we've confirmed that. And we'll go on to our third case study. And I'll call on Anita because you're next on my list. Oh, well, you know how I always kind of get ahead of myself a little bit with the next question. So I did it again, but let me go ahead and ask Anita the question. A natural language search is also called a Boolean search, true or false?
False.
Okay, I'm going to assume that means, because you said that with confidence, you know what a Boolean search is. Explain to the rest of us, what is a Boolean search? Simple term, just your simple analysis.
I actually found it in the textbook, but I went a little ahead. But
That's all right.
it's basically like researchers would have to choose a specific search box based on whether they were using terms and connectors to search.
Yep. So it's you. Well, let's see here. It searches all of the databases, but what a Boolean search is, it's a fancy way of saying terms and connectors. So, for example, if I wanted to look up, let's say mental suffering, let's just say Mrs. Vanderplatz is in the state of Ohio, and I wanted to use what we are calling here a Boolean search, I would type into my search bar, quotes, mental suffering, end quotes, and quote, Ohio, end quote. So it's like you're taking two words and you want the research to find the overlap of those two words and to get you something. So it's the opposite, well, not the opposite, but it's on the other side of natural language. So this is where you're actually using keywords and you're using some of the, you're using quotation marks if you want to find exactly something like, for example, mental suffering. You can use things like, let's look at the word suffering. What if you didn't want suffering, but you also wanted suffers and suffered and all the different variations in the English language of the word suffer? Then you would use SUFFER with an exclamation point, and that would pick up all the different variations of the word suffer. So these are like little codes, code ways of searching, which is not natural language, but it's essentially called a Boolean search. That's the old term or the original term. So knowing that, Anita, a natural language search is also called a Boolean search, true or false?
Oh, false.
False. And that is correct. Because a natural language search is called a natural language search, and a Boolean search is sometimes called terms and connectors. And that's where you take specific words and you use a special code to help the query know what it is that you're asking. It's a little bit more it's a little bit less intuitive, and a little bit more you have to follow a specific format, a little bit more specific. So we'll get into that, I'm pretty sure, as we get into the next question here. And I will now call on Paula because she's next on my list. So Paula, we have the same set of facts as before, and now we're delving a little bit deeper into the nuances of natural language search, Boolean search, and what I've been referring to as terms and connectors. If Allison chooses to conduct a terms and connectors search, so that's what I've been saying, right? Like over and over, and we haven't really had anything to look at to help me explain what that is. Using the connector, here we go, parentheses /s, parentheses. So open paren, close paren. Using this type of code between the terms, it'll do something. What is that something that it's going to do? It's either going to A, retrieve all the documents in which the terms appear within a certain number of words of each other, or it's going to retrieve all the documents that contain either search term, or it's going to retrieve all the documents that contain both the terms in the sentence. So for example, if you use a word, let's just say mental, and then we use this little code here, paren /s, close paren, and then we put suffering, it will retrieve all the documents that contain both of the terms, mental and suffering, in the same sentence. And so the /s, we're guessing that means same sentence. Or it will retrieve all documents that contain both terms in the same section. So here the answer is making you think that the /s means same section. So with all of that detail in mind, Paula, which one do you think is the correct answer?
Answer C.
And the answer is C. Can now help me understand, because all of these sound somewhat similar. Why did you choose C?
Just because from reading the chapter, I went over what the /P meant, /N/S, and I just remember from learning that in the chapter.
And you are 100% correct. So I'm going to come back to you because you shared some information that I'd like to share with the class. So Paula is 100% correct. When you see this /s, Paula, it means same what? Means find these words in the same
Sentence.
Exactly. Now, what if you see this slash and the letter P? That means find these words in the same
Paragraph.
And you mentioned the third one. Let's see if I can quiz you on that one. /n. What does /n mean when you have two words and a /n in the middle?
It's going to be answer A with a certain number of words that appear for each other.
So like these two words within 3 words of each other, right? Or these two
Correct.
terms within 5 words of each other. Because oftentimes the closer the two terms are, the more likely that that's what you're looking for, right? And if you go with like the word mental and then 20 words later suffering, that's probably not what you're looking for, right? You want those two words close together, probably like within 3 words of each other, and that's a pretty common number of words. So that's excellent. So these are terms and connectors. There's a special code that you use in between your two words, /s/p/n, and there are others, but this helps you get a tighter search result closer to what it is that you're looking for. So excellent job. Well done, Paula. Let's go to the next one. All right, now I've got Lauren. And Lauren, it's the same set of facts, and I'll read you the question. To validate the statutes and the cases that she finds online, Allison would use Westlaw's online citator, Shepherd's Online. Is that true or is that false?
I'm going to say false.
False, okay. So let's check to see if that's correct. I'm going to check my work. And you are correct, Lauren. To validate statutes and cases that she finds online, Allison can use Westlaw's online citator, absolutely, but it's not called Shepherd's Online, right? That's what the competitor's online citator is called. For Westlaw, their online citator is called KeyCite. And it seems like a nuanced detail that maybe you can easily look up. But these are the types of details that you will be tested on in the midterm, FYI. So they do go that level of minutia. So just do keep that in mind. For Westlaw, if you want to check if it's good law, if you want to make sure that the law is current, has not been overturned, doesn't have any negative history, hasn't been rejected, hasn't been modified, all of those things that would tell you that your law, that the case you're relying on may not be good law. If you're in Westlaw, then you're going to be looking at what they call KeyCite, KeyCite. You just keep that in mind. All right, we'll go to our next question and we'll go back to Seppi here for question number 6. So Seppi here, we now have a different fact pattern and so new questions based on that. If Allison's law firm did not have a subscription to Westlaw, she would have to have done her search using other sources. She will have to do a quick comparison to see which source would give her the information she is seeking. So based on those set of facts, we now have our question. Versus law provides access to federal primary sources, but omits state and tribal court decisions. True or false?
Is false because it provides access to both federal and state courts decisions.
You're 100% correct. So let's go ahead and confirm what we already suspect. And this commercial legal research tool called Versus Law, not only does it provide access to federal primary sources, but it also includes state sources and tribal court decisions. And when we use the word tribal court decisions, we're speaking of the Native American indigenous courts. They have separate courts. So, and we haven't talked about that at all, to be honest with you. It's a separate jurisdiction, separate courts. And those decisions would be called tribal court decisions. So you can find federal, you can find state, and you can also find the tribal court decisions in this commercial research tool known as Versus Law. So that's a new one. We haven't talked about it before, and we really haven't mentioned tribal court decisions. So there's two new pieces of information here for us. Well done, Sep here. Right? I'm now going to go to Kate. So Kate, we've got the same set of facts, but we've got some more nitty-gritty decisions or options here. So the search types that are on Versus Law, so it's the same, we're looking at the same vendor here. What are you going to find in there? Are you going to find A, the docket, B, the judge, C, the attorney, or D, all the above? So let's talk a little bit about, some of these are obvious, some of these are a little bit less obvious. Do you know, Kate, what is a docket? Have you heard, do you watch Law and Order? No? Okay.
Yes, I've heard the word and
Okay.
I don't know
Don't know off the
definition.
top of your head what it is. So next time you watch Law and Order, I want you to listen. So what will happen is you'll be in the courtroom and the bailiff will call out docket number X, Y, and Z dash 35. And then the two attorneys will, walk up to the tables and then they'll start addressing the judge. So the docket number is essentially the case number. And that's how the bailiff calls you to the front of the courtroom and says, your case is next. So docket number is the case number. So that's the docket. Obviously, the judge is the judge who's hearing the case, right? So the judge who's hearing the case, that would be his or her name. And the attorneys would be the attorneys representing the two parties. So knowing that, having that background information clarified, when you go on Versus Law, what kind of information will you find, or how can you search for a case on Versus Law? And what are you thinking?
I'm going to go with all answers are correct.
Okay, because it seems to make common sense, right? If you've got one, then you could probably get the other.
Yeah.
You're kind of connected, right? We're not hanging out in space. We're all going to be in a similar overlapping world, and you are 100% correct. You can search by the docket, you can search by the judge, you can search by the attorney. Once you pull up the case, you're going to have all of those pieces of information on that case because it's kind of, it comes with the case. So you're 100% correct. So this vendor, I call it a vendor because it's an option, right? You can use Westlaw. You guys have probably heard of Westlaw. You may have also heard of LexisNexis. And I hadn't heard of Versus. It's not as common. Versus Law is not as common as Lexis or Westlaw, but it is one of the commercial vendors out there. So that makes sense to me. I'm with you. Alrighty. So now we go to Anita. And Anita, we're going to talk a little bit about some of the symbols that you find when you do research with some of these different internet sites. The question asks, which of the following sources uses or used a green thumbs up icon to demonstrate that a citation is still good law? Because we always want to know if our case that we're relying on, if it's still good law. It's probably one of the most important things we want to know. So we have some choices here. Some of these are real and possibly some of these are made up. So Bloomberg Law, A, Fast Case, B, Versus Law, C, or Casemaker, D. Which one do you think will indicate a green thumbs up if a case is still good law?
I believe it's D, Casemaker. I'm pretty
Okay.
sure I read over
Say that
one.
one more time.
I believe I saw, I can't remember where I saw
You
it
saw it somewhere. Okay.
for Casemaker.
You're 100% right. It is Casemaker. So if you are using Casemaker to do your research and there's a green thumbs up next to the case site, that's a good indication to you that that is a case you can rely on while you do your work because it is still good law. And I think a green thumbs up is kind of universal, right? Like if you see a red flag, I think universally someone is telling you, be careful, right? Or I don't know, an orange box. I think that was a couple of weeks ago where one of the vendors, they used an orange box. And I think green thumbs up universally generally means you're safe to go or you're safe to use this. So well done. And that also highlights the fact that when you don't know the answer to a question, use your common sense, right? Use what you think would make sense because the whole point is to try to convey information to people, and they're going to try to convey information to people in a way that is most easily understood. And I think green thumbs up, we all understand that that's pretty good. So we'll now go on to question 9, and I will call on Paula. So Paula, same set of facts. Now we're going to talk about another vendor of research for legal research, and that's called Fastcase. Fastcase uses its own limited search of terms and connectors, true or false. What do you think, Paula?
I think this is true.
Okay, let's check. And you are correct. Fastcase does use its own limited search of terms and connectors. That is true. And if I remember, if memory serves me, Fastcase is something that they use with another system called Pacer. For those of you who are working on your co-ops, have you guys run into Pacer or any of these newer names like Fastcase or the one that we had before, Versus Law or Casemaker? Do these names mean anything to any of you, or are they new? Is this new terminology for most of you? I'm going to take from the
I would
side.
say is
Yeah, go ahead,
I
Lauren.
would say it's new.
New terminology. And that
I
makes
would
sense
say
because
it's
these are
new.
not
I
as
feel like the only
common.
one that would,
Sorry?
yeah, I would say the only one that'd be close would be like LexisNexis.
Exactly. I think that Lexis and Westlaw are the two, as far as I'm aware, the two top vendors. And all of these other ones are smaller, maybe a little bit more focused, maybe less expensive, and maybe that's why we haven't heard about them so much. So well done here. We'll go to our question 10. And I will call on Lauren. So Lauren, there's this other one which we haven't talked about before, and actually I'm learning about for the first time. It's called Hein Online. Kind of makes me think of Heinz ketchup, you know? So now I'm getting hungry. I need some fries. Hein Online is unique because it delivers its search results by PDF. And PDF is a format that is a little different from Word. In a Word document, when you get a Word document, if you're working in a Word document, you can make changes, save, make edits, etc. A PDF, I've forgotten the technical term for PDF, but when you get a document in a PDF, you cannot alter it. It's you can download it, you'll get exactly what it looks like, and you cannot make any changes to it. So the question is, if you're using this tool, Hein Online, are your results going to come by PDF, true or false? And what do you, let's
True.
see. Yeah, you are correct. It is true. So again, it's a detail, right? And you may ask yourself, well, I don't know, is that really a super relevant detail? This is a way for the book to kind of just show the distinction between the different types of online research providers. So, with a PDF, you can't go in and copy. Well, it depends on if you have Adobe Acrobat, but you typically cannot go in and like copy and paste. So you couldn't copy and paste it into your research, and that might be a limitation. So it's good to know. All right. So that concludes our case study analysis for Chapter 8, Commercial Internet Research. Before we move on, does anybody have any questions about Chapter 8? Either about the case studies or the text or the quiz or anything of that sort? And if I take the silence as a no, then what I would like to do is, let me go ahead and close this out, or actually I need to be able to get into the book. All right, we'll close that out and let's shift gears now and let's talk about the midterm. And let's talk about all the things that you need to know in order to be prepared for it and in order to do well on it. So So all of here, one second. So all of you have seen now this particular basis for grading from our syllabus, and I'll focus again on the midterm and the final exam. Midterm and final exam are worth 20% of your grade. The item which is worth the highest percentage of your grade are the weekly projects that that you guys turn in every week. But a midterm and an exam it's not peanuts, it's worth 20% of your final grade. So I'd like to at least remind you guys all about that. And here are kind of like the nitty-gritty of the exam. So it is open now. You can take it today. You can take it all the way up until October the 19th, which is this coming Sunday. It must be submitted by 11:59. Now, if you start taking the midterm at 11:15 p.m., what's going to happen at 11:59? It's going to auto-submit. So wherever you are, it's just going to turn it in. So you don't really want to work that close to your deadline because that always seems to concern students. Yes, Kate.
I just tried to open the midterm and it's telling me I can't take the quiz at this time because this
Okay.
isn't active. I just tried opening it because earlier this week I tried to.
Same thing. Can you
Yeah.
do me a favor, Kate?
Yeah,
Can
I was
you
gonna say it did it. I was about to say it just did it for me too.
Same.
Yeah.
Kate, can you send me a screenshot of that? If you
Yeah.
don't mind, just send me a screenshot and send it to my email, and then I will work with the head teacher to fix that. Because
Okay.
I checked it this morning, and so I see things from the instructor's perspective, and I can't always see things from your perspective. But from my perspective, it was active, so I have to take care of this. So thank you very much for both of you for bringing that to my attention. So once I clear that little issue up, you should be able to complete it as soon as I figure out what it is that's holding it up. A couple things to keep in mind. So big picture, the midterm is not over every single chapter that we've covered from day one. It is on a select number of chapters. They are chapters 1 through 7 and chapter 12. So that's chapters 1 through 7 and chapter 12. So that's a total of 8 chapters that will be covered over the midterm. So number 1, that's the scope. Number 2, you have 90 minutes to complete the midterm. You have 90 minutes and it consists of 45 questions. So you do not have, well, let me back up a little bit. 90 minutes, 45 questions. You get one attempt. So this is not like a quiz where you can take it multiple times and keep the higher score. You get one attempt. And the multiple choice questions they are not A, B, C, and D. They are often A, B, C, and D, and then A and C is correct, or B, D, and E are correct. And those will slow you down a little bit, right? Because if you've just got an A, B, C, D, it's kind of easy to pick the one right answer. I'm going to tell you, because I took the exam this morning, many of the answer choices are A and B is correct, or A, D, and E are correct. Or so you have to, it's more difficult that way, right? So I want to let you guys know, and I'll go over that, the details do matter for this particular exam. So 90 minutes, 45 questions. Once you start, you have to finish. You can, how to say, I believe once you answer a question, you can go back to it to double check that you got the answer that you chose is the answer that you want to keep. Let's see here. And I think those are the basics, right? 90 minutes, 45 questions, one correct answer. You choose one correct answer, and it should grade right away as soon as you submit. So you will know how you did as soon as you hit submit, like within 30 seconds. So with that in mind, what I would like to do is I would like to go over each chapter with you, not in detail, but to give you an overview and to help you know what to focus your time and effort on in each chapter. And I will take questions as we go through each chapter as well. So if you have questions, this is the perfect time to ask them. Make sense? All right, so we'll start at the beginning. We'll start with chapter 1, and this will kind of be a refresher for you and also a strategy. Like how do I approach this midterm? So I'm going to go into the book, and then I'll share my screen with you guys. So I've got both my hard copy book and I've got my online book. Okay, now I'm going to share with you guys. All right, so here's chapter 1, and chapter 1 is entitled An Introduction to Legal Principles and Authorities. One of the things that I would like you guys to focus on as you review these 8 chapters is oftentimes there is an exhibit, 1 or 2 within each chapter, that summarizes the key points of each chapter. And it does it without having to, like, you can't memorize a chapter. Obviously, that's just too much detail, too much information. But you want to be able to look at the main points, but also be able to have some detail to support. And what I've done is I've gone through each chapter and I have found those exhibits that if you either want to like take screenshots of them. Oh, that's what I forgot to mention. Sorry. The exam is also open book and open notes. So you won't have time to answer each question by looking it up. There's not that kind of time. But if you organize your notes, you will have enough time to kind of refer to your notebook or to refer to your book and look up something quickly if you already know that it's been discussed. So if that makes sense, what I want to do is I want to start with Exhibit 1-2, and I want to just show it to you guys. And it might be easier if I just go with the page number. So let's see here. Page 9. Nope, I don't want to do that. When we would, oh, here we go. Okay. So I want to find Exhibit 1-2. There it is. Okay, here's 1-1. Okay, so we're going to skip 1-1. 1-1 is really just like a geographic map of the country, and it shows you where the courts of appeals are and where the district courts are. That's way too much detail. That will not come on the exam. But 1-2 is a good exhibit, and this is where we will start. So I've gone through, and I think there are ways where you can, but I want to say there's got to be a way where you can put a little post-it here electronically. And if not that, at least maybe it's this. Okay, I'm making things complicated. Oh no, what did I do? Hang on. Okay, I don't want this. Let's see here. Try that. All right, give me a quick second. I want to figure out where I was. All right, here we go. All right, now I can search by page number, and that's really what I want to do. Okay, I want to go to page 9 because that's where our first exhibit is. And I want to have you guys just bookmark Exhibit 1-2. So Exhibit 1-2 talks about the federal court system and the organization of the federal court system. Just by looking at this quickly, you can see what is our highest court. That would be the Supreme Court of the United States. And then we have our appeals courts and our trial courts. Trial courts are always going to, well, they're typically going to be district courts. That's the bulk of what I'm familiar with. But you also have these specialty courts, for example, Court of International Trade, the Bankruptcy Court, the Tax Court. These are courts of limited jurisdiction. And what does that mean? That means that when you're in the United States Tax Court, you should not be talking about bankruptcy, right? You should only be talking about tax stuff. When you're in the bankruptcy court, you should not be talking about, I don't know, tax stuff, right? These are what we call courts of limited jurisdiction. And I don't want to go into the weeds here too much. I just want to let you know these are the trial courts of the federal court system. When a judge makes a decision here, the losing party, if they want to appeal that case, they would appeal it to the courts of appeal. And then if the losing party wants to appeal that case, they can ask the Supreme Court to take their case. And then it's up to the Supreme Court if they want to take it or not. But this is an overview. This is a visual overview. I find this to be really helpful just so you understand the overall structure of the courts. So this is Exhibit 1-2, and it is on page 9. It is the first exhibit that I have posted on my book, and I recommend that it would be helpful to you because you get a lot of information in a quick look. And that's really what you want, right? You want to be able to get a lot of information in a quick look. So some of the other topics in Chapter 1 that you should be familiar with are the issue of precedent. You know, we spent quite a bit of time talking about that. That's on the next page. You should also be familiar with the terminology stare decisis. And stare decisis and precedent are related. If you remember, precedent is when you have an earlier court decision that that you want to argue applies to your current client's case, right? That's what precedent is. And the reason why we like it is it creates uniformity, some degree of it minimizes the chaos, right, of different decisions being made by different judges. You know that if there is an earlier decision that the court has relied on and that applies to your case, you would then argue for the judge to apply it to your case based on precedent. And then its related cousin is stare decisis. It's a doctrine, the doctrine of stare decisis. That's a principle that says that courts should follow the decisions that judges have made previously, same facts, same law, or similar facts, similar law, right? The two go together. And I also want to point out to you Exhibit 1-3. This is on page 13 of your text. I really like this exhibit because it takes a lot of Chapter 1 and it condenses it for you so that you can compare and contrast the different types of authority in legal analysis. So we talked about primary authority, what it means, and secondary authority and what it means. So primary authority is the law itself. That can be a constitution, a statute, an ordinance, a rule by an administrative agency. It can even be a court opinion. So these are examples of primary authority, and the chart helps you to compare and contrast primary authority to secondary authority. What is a secondary authority? Well, that's when it's not the law, but it's something that's helpful and helps you learn about the law. It can be an encyclopedia, can be a law review article, and there are a couple of examples here. So if I were you, I would either bookmark this page or not this page, this exhibit, or take a screenshot and have it available to you under Chapter 1. And then it's important to understand mandatory authority versus persuasive authority. The key here is that for mandatory authority, A court must rely on this, MUST, when making a decision, versus persuasive authority, a court may rely. So there's some discretion here. And that actually matches, right? If it's mandatory, you have to do it. That's a must, right? That makes sense. If it's persuasive, you can be, how to say, the attorneys can argue and present their case, and you may or may not be persuaded. So it's really up to the court how convincing the arguments are that the attorneys are putting before them. So that's Exhibit 1-3. So if you're making a list of the exhibits, the first one was 1-2. The second one is 1-3. So that's our second exhibit. Let's see if I've highlighted any more. Just bear with me. Okay, so for chapter 1, those are the two that I've highlighted. The other thing that I'd like you to review as part of your review are, and this goes for every chapter, I would go to the key points checklist, because they kind of just go through the main points. And then there is actually a separate summary. So every chapter will have a key points checklist and a summary. If you don't have time to reread the whole chapter, and again, you may not be able to retain everything, look at the exhibits, go over the key points, and look at the summary. And I think that's a good way for you to review chapter 1. Okay. Before I move to chapter 2, does anyone have any questions about chapter 1? Okay, I'll take the silence as a sign of go forward. So now we go to chapter 2. Chapter 2 was our introduction to legal research and analysis. Why is it not cooperating? Chapter 2, so let's go there. It should be page 26. Why are you not cooperating? Book contents. Introduction to legal research and analysis. Over here. All right, bear with me while I try to figure this out. Why, this should be very easy. All right, I guess I have to, for each chapter, I have to do this. Okay, so here we are in chapter 2, Introduction to Legal Research and Analysis. And let me highlight for you the exhibits, which I think you should be familiar with. So we've got exhibit 2-3. See if I can pull it up for you. Actually, let me back up a little bit. I believe that Exhibit 2-1 is also helpful. This is an overview of the IRAC analysis. This is the issue, rule, analysis, and conclusion. We did a project on this very specific analysis or process early on in our class, and this is helpful. So Exhibit 2-1, I'm going to mark that in my book. And the next exhibit that you should be familiar with is Exhibit 2-2. Exhibit 2-2 talks about the 3 parts of the step 2 rule. Okay, so as you guys can see, I'm struggling. I thought if I could show this to you, it'd be easier and we could all follow along together. It's not exactly working as I had imagined. Okay. So I don't want to confuse you guys. So let me just make it easy and simple. So Exhibit 2-1, Exhibit 2-2, and Exhibit 2-3. I would be familiar with those 3 exhibits and Exhibit 2-4. The other thing that I would be familiar with, particular to Chapter 2, but also as a general rule, when we have talked about steps to doing legal research, sometimes we will talk about step 1, step 2, step 3, like we'll enumerate it that way. When you see that, that's important. So for example, let me change my glasses and give you guys an example. There are a lot of those in Chapter 2. There are a lot of, if you look at each of these exhibits that I've gone over the numbers with you, for example, Exhibit 2-1. So if we look at Exhibit 2-1, and I don't want to lose you by trying to find it, but Exhibit 2-1 is titled Steps in the IRAC Legal Analysis Process. And what it does is it talks about step 1, finding the issue. That's the legal issue that you're needing to research. Step 2 is identifying the law or the rule that governs the issue. Step 3 is the analysis. How does the law apply to your facts? And step 4 is your conclusion. So whenever you see a type of analysis that is separated out like that, pay attention, because that's great. It's a great place for a question to come up, right? Like, what's step 3 of the IRAC process? Or something to that sort. And if you'll notice, we spent a lot of time talking about this. When you look back at it, it should feel familiar to you because of the amount of time that we spent going over these things. So there's 2-1, and the same with 2-2. There are 3 steps in 2-2, and Exhibit 2-2 is actually called 3 parts of step 2, the rule. So all of these exhibits, particularly in Unit 2, have steps. Oftentimes they'll have 3 steps, sometimes more, but I would screenshot those. That's where you're going to find some really good information. Okay, so that's Chapter 2. So Chapter 2 is heavily focused on the exhibits and the steps. All right, from here, let's go to Chapter 3. Let's see if I can actually pull it up for you guys. So Chapter 3 was entitled, or is entitled, Constitutions, Statutes, Administrative Law, and Court Rules, hyphen, Research and Analysis. So that's a mouthful. Let me grab this screen for you guys. And from Chapter 3, let me find you my Post-its. want you to pay particular attention to Exhibit 3-14. And Exhibit 3-14 is entitled Statutory Analysis Three-Step Approach. So it is important to understand the concept of statutory analysis and also what are the steps, what are the steps that you would take to do a statutory analysis? And that can be found in Exhibit 3-14. Paula, go ahead, please. Paula, do you have a question? No? Okay. I thought there was a question. So Exhibit 3-14, you'll see 3 steps there.
Oh, I'm sorry. I was on mute. I was saying if you refer to, excuse my dogs, if you hit exhibit, sorry, if you hit the exhibit numbers that are highlighted, it should take you directly to the exhibits.
So say that one more time, Paula, because I'm struggling here with that.
If you select the highlighted exhibit numbers referenced throughout the book, it should take you, I'm sorry, exit back out.
Exit back out.
In the paragraph where it's highlighted blue, it's in blue, Exhibit 3-3.
Oh, okay.
If you select those, it should take you to the exhibits you're looking for.
Fantastic. Okay, so let me find I want to find 3-14. So they're not all like in logical order. But I hear you. So if I click on any of these, it'll take me straight there, which is ideally what you would want, right? That would make sense. So then how do I find Exhibit 3? Well, maybe if I search this course and I type Exhibit 3-14, maybe that will take me there. That's why before class, I went and I did all of these in my book so that it would be easy for you guys, but it's not really working out. Okay, here we go. Thank you, Paula. Okay, here we go. Here's Exhibit 3-14. And this is what I was talking about. There's a 3-step approach to statutory analysis. This is an important concept from Chapter 3. And from my notes, that is the only exhibit that I have created a post-it for. Again, I would encourage you to look at the 2 parts for every chapter, the key points checklist and the summary. So I would do that for every chapter. I would look at the exhibits, the key points checklist, and the summary. So chapter 3, you've got here the 3-step approach to statutory analysis. I'm now going to go to chapter 4. Okay, so chapter 4 is where we started doing our case law research and briefing. And you guys had all submitted your own case brief for, I don't remember, maybe it was State v. Johnson. It was about the search warrant. And you guys had all submitted your case brief to me. And we talked about how to brief a case. We talked about the different elements or different parts or components of a brief. And let's see if I posted anything here on any of the exhibits. So Exhibit 4-1 is called, it's a court opinion, and it's about this State Farm case that I'm not sure if we talked about it at great length in the class, but the reason I like Exhibit 4-1 is, here's 4-5. Okay, so that means I've gone too far. So Exhibit 4-1, let's see if that'll help me. Yep, that's it. Okay. The reason I like it is because No, how are we in? Okay, that didn't work very well. Bear with me. We're in chapter 4. Okay. This is a smaller version of it. Here's Exhibit 4-1. It's the court opinion. The opinion is not really what I want you to take away from here. What I want you to take away is the labels. Like, here's the citation, here's the caption, here's the syllabus. So what kinds of things would you find in a court opinion, right? So it's really just an example. You'd find head notes and key numbers. You'd find the opinion, obviously, the attorney's names and stuff. But just knowing a little bit about the layout of what is going to be in a court opinion is useful. And that's Exhibit 4-1. The other exhibit is 4-4. Let me see if I can take this straight there. Exhibit 4-4 is entitled Research Sources and Techniques for Locating Cases. Oh, I think it's okay. It's the next page. Here we go. So Exhibit 4-4, Research Sources and Techniques for Locating Cases. Here you have a table here that summarizes what you would find if you looked at a statutory annotation. You would get not only the statute, but other cases that follow that statute. If you use a digest, what would you get? If the question that you're researching does not have a statute or you don't have those annotations, then you can go to a digest to start your search. Other things that you can use, law review articles, encyclopedias, this word that everybody struggles with, treatises, ALRs. And what about Shepard citations and what Westlaw refers to as key cite? Well, you go there if you want to make sure that the case you're working on is good law, meaning it hasn't been reversed, it hasn't been modified, it hasn't been overturned, there isn't negative history about it. Then you would look at these sources here. And then we've talked today about Westlaw and Lexis as being the two main commercial providers of online research. So that's Exhibit 4-4. I would mark that one. I would mark Exhibit 4-5. This talks about the case brief format. And I briefly mentioned that because one of our weekly projects was to brief a case. And I asked you to divide it up based on the different categories. And that's going to be in 4-5. Here we go, case brief elements. So you've got your citation, that's the name of the case and where you can find that case, your parties. Your parties are going to be whoever is bringing the action and against whom they are bringing the action. Oftentimes your plaintiff and defendant. Your facts, what are the facts of the case? You'll get a summary of the facts. What kind of facts? Well, they would be the relevant facts, right? Because you don't have enough, or key facts, you don't have enough space to write down everything. You have to focus in on what the court calls key facts, or sometimes what I call relevant facts. The procedural history is going to be, how did the lower court rule, and was that case then appealed from the lower court? Oftentimes the losing party is the party that appeals. So that's where you have your procedural history. Your issue is going to be the legal issue and or issues, and sometimes there's more than one, that the court is specifically addressing. And you want to make that issue as narrow as possible so you can stay focused in your research. The holding is what the court decided, and then sometimes you can have comments, about the opinion. So these are the basic parts of a case brief, and a case brief doesn't have there's a little bit of wiggle room, right? It doesn't have to all look the same. There's room for you to modify a little bit, but these are the main bits and pieces of it. So that's Exhibit 4-5. Let me see if I have anything else in my notes. And again, as for all the chapters, make sure you take a look at the key points checklist and the summary. And that's where you're going to find all the chock full of, it's going to be chock full of good stuff. So in addition to the exhibits. So that is chapter 4, case law, researching and briefing. That takes me to chapter 5, unless you guys have a question. And let me know, am I going too fast? Am I speaking too quickly? Am I going too fast? You guys all comfortable? Okay. So we go to chapter 5, and let me pull that up. Okay, here's chapter 5. In chapter 5, we started talking about secondary authorities. And we broke them up into encyclopedias, treatises, the American Law Reports, digests, and Shepard's. So that there was a lot that we covered in chapter 5. Let me see where so the first exhibit that I believe you will want to focus your attention on is Exhibit 5-1. And the title of it is Secondary Authority, Primary Use as a Research Tool. Here it is. No, sorry, went too far. There we go. So the reason I like this particular exhibit is because it took all of the items that were in the title, all of these secondary authorities, and it helps you compare and contrast and know what's unique about each one. So for example, starting at the top, legal encyclopedias. We spoke a few weeks back that if you were researching an area of the law that you'd never researched before, and you wanted to get a broad understanding or an overview, that would be a good place to start. So legal encyclopedias are wonderful to get an overview of a specific area of the law, and that will help you find your cases. So your next option is to go to a treatise. Treatise is something that is, when you want a more general summary, hold on, let me read this properly. Use when you are seeking more than the general summary of the law available in a legal encyclopedia. So with each one, you're going to get more and more detail. Legal encyclopedia, very general overview. What if that's not enough? What if you want more details? What if you want some analysis, maybe even a criticism? That's when you go to the treatise. So as you go down this exhibit, you're going to get more and more into the weeds. General overview, legal encyclopedia is wonderful. If you want more in-depth discussion, if you want explanations, analysis, and criticisms of the law, that's when you will go to a treatise. What if you want to go even more into the weeds and you want to have a comprehensive analysis of a very narrow legal issue? That's when you would go to the ALRs, which are the American Law Reports. This is where you're going to get in-depth discussion on a very specific legal issue, and it's going to be more in-depth than the one above it, which is the treatise. So each one below is going to be a little bit more detailed than the one above. A digest is where you go to get very specific points of the law. They're helpful if you know the name of the case and you're looking for other cases that support your point, or if you don't know any of the cases and you're looking to find one. So digest is useful under those circumstances. And the last category, which I think is one of the most important, is once you find your law, you have to confirm whether or not that case is good law. And the only way you can do that is if you shepherdize. Now, lawyers call it shepherdizing, but depending on which tool you're using, they may use a different term. Shepherds is the old school term. It's the term I learned going to law school. But today, technically, if you're using Westlaw as your research tool, they call it key cite. So it's the same thing, though. You're checking to see if it's good law. So either you can use a Shepherd citator or you can use a Westlaw key cite. The two things do the same thing. They check if your law is good, if your case is good, and generically lawyers call it shepherdizing. So I believe this is really a great exhibit because you get all of that information at a quick glance. So I really like this one. I'm going through my book to see if I've got another one for this chapter. I don't have another exhibit, but I do want to reinforce the importance of being able to understand the difference between the categories in 5-1. All of the secondary authorities that we talked about, you should be able to distinguish them. And you should know also how to check if a case is good law. And I just went over that, but we spent quite some time talking about that. Those are the two takeaways from chapter 5. Okay. That brings us to chapter 6. So in chapter 6, we continued our discussion about secondary authority. Let me pull it up for you. So in chapter 6, we continued the conversation about secondary authority, but this time we included topics that we didn't cover previously in chapter 5. So now we're looking at periodicals, restatements, something called the uniform laws and model laws, dictionaries, legislative history, and even more secondary authorities. So this is kind of whatever we didn't cover in chapter 5, we addressed all of those items in chapter 6. And again, I have a favorite exhibit here. That's going to be exhibit 6-1. Exhibit 6-1 should be right at the beginning. There we go. This is a similar table to the one we found in chapter 5, secondary authorities, primary use as a research tool. And it's going to distinguish between the main categories of secondary authorities that are left over after we cover the ones in chapter 5. So here, the first one is periodicals. This is where you're looking for an analysis and critique of a specific legal topic that is more in depth and more focused than an encyclopedia or a treatise. So remember, that's all from chapter 5. We talked about that. What if the treatise is not detailed enough for you? Well, then you can go to periodical. What is this thing called the restatement of the law? We talked about this because I wanted to show you how in the word is oftentimes are the clues to the definition. A restatement is where you restate the law. And why would we need to do that? Because we are a large country. Our laws have developed over time and over geography, and that lends itself to having some inconsistency. And if you want to teach people, if you want to have a standard definition, across the country, then you have to take that law and you have to restate it. You have to say it again in a really simple and clear way. And then you connect it to the cases and the treatises and other secondary authority. So a restatement of the law is essentially where you're trying to standardize the definition, make things uniform by taking the law and saying it again in a way that everybody can agree. That's the restatement. Uniform laws and model acts. This is where you don't want to reinvent the wheel or start from scratch. If you need to pass a law in an area that your state has not passed, or you're looking for a sample law language, this is where you would go, because a group of legal experts has done that. They craft what we call model laws or uniform laws. It helps make the legal system a little bit more uniform. These are like proposed languages and proposed, they're not all passed by all states, they're proposed, but states can choose to adopt them, and it's oftentimes easier than from scratch making up your own law. So that's one way to have some uniformity. Obviously, we know what a dictionary is. It'll help you spell and pronounce and give the legal meaning of a term. The one that most of us grew up using was called Black's Law Dictionary. I still have it on my bookshelf. And it helps create uniformity. The last one we didn't talk about so much, but I do want to highlight it for you today because we didn't spend a lot of time talking about it. There's also a source known as legislative history. And this means that when you pass a law, there's going to be all of this commentary and history that comes with the law. So if you're trying to figure out how do you interpret a statute, because a statute is a law, if you're trying to figure out how to interpret it because there's some ambiguity, something's not clear, that's when you go to the legislative history. And you'll find all sorts of notes and committee meetings and committee hearings and, kind of all of the stuff that went on while the state was trying to pass that law. So if parts of the law are not clear, then you go to the legislative history and you try to argue your position of why it should be interpreted the way you want it to be interpreted. Or if it's so broad that, it's not clear, again, you go to the legislative history and you make your arguments if you want the law to be read a certain way, depending on, the facts of your case. So that's Exhibit 6-1. So I recommend that you should be familiar with these items, what they are and how they're different. I'm going through my chapter 6 to see if I have any other post-it notes. We didn't talk about jury instructions. Jury instructions, so there is a little section on it in chapter 6. Let's see if I can pull it up. For me, it's on page 215. Oh, here we go. Jury instructions. It's another resource that you can look to primarily because a jury instruction is going to be written in a very simple way so that your jury members can read it and understand it. What it essentially does is it puts out the elements of a cause of action. What do I mean by that? Let's say you've got a case going on in court and your jury has to determine if a person is guilty of, let's say, assault and battery. And that's a tort, so we'll use that as an example. The jury instructions are the instructions that the court is going to give the jury, and it's going to say something like, in order to find, a plaintiff guilty of assault, a plaintiff has to, you have to show these three elements. So you'll look up what assault means in that state's definition, and in order to be guilty of it, what does the prosecutor have to prove? Okay, typically for assault, there has to be a fear element, like you're afraid because someone's going to punch you and you see the punch coming and you get scared. So there's that fear element. So they're going to, and if it's assault and battery, then it's also going to be the fear and also the contact, like somebody made contact with your body in a way that caused you harm. So those are all like elements of the thing that you're being charged with. Jury instructions are going to list all of those elements, and they're going to list them in a way that's really easy to understand. So if you're wanting to include that as a secondary authority, you can include jury instructions. It's kind of unusual, it's not unusual. It's kind of not something that people know commonly, but it is available to you as a resource. Let's see if there's like a little. Yeah, here, as I said, jury instructions provide the definition of a term, the elements of a cause of action that you have to prove, and that which that particular state has adopted. So it's another resource, and you can use it if you find it to be helpful in making your argument. So we didn't talk about that one too much before, if at all. Again, go back to the key points checklist and the summary to get a nice overview. And I don't have any other exhibits for chapter 6. So that takes us to chapter 7. Close this one out. Okay, bring over chapter 7. And chapter 7 is where we started talking about computers and internet legal research. This is, I think, our introductory chapter to this topic. I would like you to take a look at the information immediately below Exhibit 7-1. So let's see if I can get you there. We talked quite a bit about how do you keep your research focused, that it's so easy to go down a rabbit hole when you're researching a new area of law. And I think that's important to keep in mind because it's a very practical, it's practical to find ways to stay focused. And we talked about some of the ways that you can stay focused, which was, know what issue it is that you're researching and know how broadly you have to research that issue. So that's another way of saying the scope. Make sure you know what the scope of your research is and what is the objective of your research. Like, what are you trying to do? You're trying to answer a legal question. That would be your objective. what is the scope of your research? Like, how narrow is it? How broad is it? If you can keep the scope and the objective in mind, it'll help you stay focused and help you from not going down the rabbit hole, which is something that happens so easily, right? You don't want to click on every website. You don't want to click on every case. You'll never get anywhere. You have to stay focused on your assignment. So I find these items here, 1 through 6, these are best practices to help someone who's doing legal research to stay focused, to be efficient and effective. So I like these because even to this day, they're useful for me. So keep your scope and the objective of your research in your mind. That's number 1. Number 2, do not aimlessly click through all the websites, right? That's how you go down that rabbit hole. So you don't want to do that. We talked about the value of keeping notes because there's just so much information. How do you know where you ended your day and where to start the next day? Well, keep some good notes. Look at what's useful. You can use your browser history to do that. Oh, that's number 4, to help you stay focused. You can use bookmarks. That's number 5, once you find something that's useful. And number 6 is really critical. You do not want to rely solely on these free online resources. They're a great place to start. You can log on to any time of the day from practically anywhere. So you have that, the ability to do your work. But the downside is that you may not be relying on good law because you're not able to confirm if the cases that you're relying on are still good. Or maybe they've been reversed, maybe they've been modified, maybe there's negative history. You have to walk into a library or use Westlaw or Lexis or another tool that guarantees that their cases are current. So it's a great place to start, but you don't want to stop there. And I think that's really important to remember as you guys not only just prepare for the exam, but just real life researching, that there's a limitation, on this free research. So let's see here. So 1 through 6 that I just covered with you guys, it's page 229. I think those are important things to keep in mind. And that takes us to the end of chapter 7. And then we skip all the way to chapter 12. So keeping in mind, class, the midterm is chapters 1, 2, 3, 4, 5, 6, 7. And then there's a break, and then chapter 12. So make sure that those are the chapters where you are looking at the exhibits, you're looking at the key points, and you're looking at the summary. So let me take you to chapter 12. It's actually the last one. And we talked about it some time ago. So this might be a good one to refresh your memory on. So back in the day, we talked about how do you know if the case that you're researching, if it's on point. We talked about what that meant. What does that terminology mean for a case to be on point? There's some value in using that terminology and then knowing exactly what does it mean. Let me see if I've got anything in the exhibits. What a postmark. Got a few post-its here. So as I mentioned, it is important to know what on point means. Understand the relationship between a case being on point and a case that you are arguing has precedent, meaning is something that you want to argue to the court, that this case is so close in the facts and the law that, Your Honor, you should decide it the way you decided this other case. You know, that's where you argue precedent. It's important to understand the difference between mandatory precedent and persuasive precedent. I know it's been a while since we talked about these things. We covered this one some time ago. Let's see if I can take you to the right spot here. To here in the book, there's a conversation about what does it mean for a case to be on point. In my book, this is page 330. What do I want to take you to? Here we go, precedent. So in my book, again, it's page 330, where we talk about what is precedent, what does it mean, what does it indicate, and the fact that there are two types of precedent. The two types of precedent are mandatory precedent, and the second category is persuasive precedent. So mandatory precedent is if you have a court opinion that's on point, right? Similar facts, similar law, then, and we talked about why that's called precedent, right? And we talked about this doctrine of stare decisis, how it basically says to the courts that lower courts, you have to, that's why it says mandates here. It means you have to follow the opinion of the lower court. Excuse me, lower courts have to follow the opinion of the higher court. I said that the opposite way. The lower court has to follow the opinion of the higher court if you're in the same jurisdiction. So if we are talking about courts in the state of Ohio, the lower court, meaning the county courts, would have to follow the precedent of the Ohio Supreme Court because it's higher on the chain. And if it makes a decision about how a certain word should be interpreted or how a certain case should be analyzed, then the lower courts have to follow it. And that is an example of how the doctrine of stare decisis works with this term called precedent. So if you see mandatory in front of the word precedent, then you know the lower courts must follow it. So I look at the M of mandatory and I look at the M of must, and I say those two are lined up. Let's see if that follows as we go to the next one. So the second type of precedent is persuasive precedent. Persuasive precedent is where a court may, M-A-Y, look to for guidance when making a decision. It is not bound to follow, meaning they have a choice, right? Mandatory precedent, you have to follow. The lower court has to follow the higher court if it's a case that's on point. But persuasive precedent is not that way. The court may choose to refer to it if they're persuaded, if they think that they want to do that. So one way of knowing if you have to make a decision about mandatory precedent versus persuasive precedent is persuasive precedent is where you might have a court in a different jurisdiction. For example, the case is in Ohio and we're in Ohio courts, but you found a fantastic case in Kentucky and you want to argue that case to the judge. Well, the judge does not have to follow it because you're in different jurisdictions, right? Ohio doesn't have to follow Kentucky. Kentucky doesn't have to follow Ohio. But if you have a really strong case and you want to argue that case before the judge, that would be called persuasive precedent because the judge gets to decide if he or she wants to follow that case because you're not in the same jurisdiction. Now, if you were both in the state of Ohio and the facts were situated similarly and the law was situated similarly, then you may try to argue that as mandatory precedent. So I know after a while all the words blur together, but this one, it is important to understand the difference, and I would spend a little bit of time maybe looking at the examples if you are wanting to make it more clear. So there's an example here about persuasive precedent, and it's very similar to the one I shared with you. If one decision is from Arizona and you're arguing in Colorado, the court in Colorado doesn't have to follow the Arizona decision, but they may choose to do so, right? That's persuasive. So do make sure that you're familiar with the difference between those two, when one would apply, when the other would apply. And here I've got highlighted in my notebook, Exhibit 12-1 as being an exhibit that I like and that I think would be good to be familiar with. Here we go. And this is really about determining if a case is on point. That is also an important analysis. We have a two-step process. How do you know if a case is on point? Because if it's on point, then you're going to argue, hey, Your Honor, I want you to look to this case as precedent, meaning we've already had it decided and all you have to do is follow it. So there's a two-step process. Step one, are the key facts sufficiently similar? This is really key here. You've got to use these two words together, sufficiently similar. They don't have to be exact, right? Because how often are you going to find two cases of the exact same facts? It's not going to happen. But if they're close enough, then you would want to argue them. So are the key facts sufficiently similar for the case to apply as precedent? That's the question. If the key facts are sufficiently similar to your client's facts, then you would argue to rely on that case. And if the facts are not similar, then you could argue it only if the legal principle is broad enough to also cover your client's case. So I would spend a little bit of time understanding what that means. And then step two are the rules or the principles of law, again, sufficiently similar for the case to apply as precedent. So in order to argue a case on precedent, meaning is just a fancy word of you're basically saying, Your Honor, this kind of stuff has already been decided. These kind of facts under this kind of law has already been decided. So all you got to do, Your Honor, is just do what the previous judge did. That's what you're arguing with precedent. But what do you need? You need to do this two-step analysis. You have to have sufficiently similar facts, key facts, and sufficiently similar principles of law or rules of law. You've got to have the facts and you've got to have the law. They have to be close, really close. And that's how you would argue a case being on point. And that's why you would also argue to a judge, listen, Your Honor, you don't need to reinvent the wheel. Just follow the last case that was just like this, or almost just like this, right? That's precedent. So that's Exhibit 12-1. I would highlight that. I would understand that. Go through some of the examples in the book, or just think of the examples that I've shared with you. The next exhibit that I want you to focus on is Exhibit 12-2. Let's see if I can get you there. Oh, I went too far. Hold on. Here we go. Exhibit 12-2. This is a three-part process for addressing different key facts. If you remember, maybe about an hour ago, I shared with you that as you go through and review these chapters and you see step 1, step 2, step 3, I want you to consider a bell going off in your head, that's a prime area for a question to come from. They love asking questions when things come in little groupings, right? And here, what do you have? You have a three-part process for determining if a case is on point when the key facts are different from the key facts of your client's case. So here, when they're different, right, we talked about that. How do you address that? Well, here's your three-part step process of how you address it. You identify the similarities. So you say to the court, Your Honor, look at how similar they are. Look at how similar the facts are. And you identify the differences. Well, actually, this is not an argument to Your Honor. This is your own analysis on your own paper, right? You look at the facts and you look at how similar they are. You look at the facts and you look at how different they are. And then you have to decide, are the differences of such a degree that you cannot argue that it's precedent. This is where your analysis and your judgment comes in, or the attorney that you're working with, and you're doing the research for them. How similar are the cases in terms of the facts, or how different are they? And the more different they are, then the less likely you'll be able to rely on that case. The closer they are, you may have a chance. You may have a reasonable argument there. It's a matter of your judgment. But this is the analysis that you will do if your facts are different from the facts of the case that you want to argue to the judge to apply as precedent. I know you guys are busy taking notes and thinking about everything I'm saying. Sometimes when I talk too much to myself, it feels like I'm speaking in gibberish. Are you guys following me? Yes, okay. I see some nodding of heads. All right, excellent. I just want to make sure I'm not going too far in the weeds here, but I do like Exhibit 12-2. And let me tell you what other one I like. I like 12-3. So let's go to 12-3. Here we go. Another one of those nuanced analyses. What do you do when you've got key facts between your client's case and the other case that, that was decided before that you kind of wanted to rely on? What do you do? Well, here you've got some guidance. What if you've got minor differences in the facts, in the key facts, your client's case and the case that you love? What if the differences are minor? Well, you could argue that the case is on point. What if the differences between your client's case and the case you want to rely on are major, meaning there's a big gap? It's not likely that you're going to have success arguing that that case is on point because it's just they're too far apart, right? If they're too far apart, then you're not going to have a strong argument to the judge. What if, why is this repeating itself? Minor differences in key facts, case on point, major differences in key facts, case not on point. Major differences in key facts. All right, you guys see what I see here? Line 2 and line 3 are identical, except for the okay. Different key fact variations. Major difference in key facts. Major difference in key facts. Okay. Well, these are your 4 options. You can either argue, if there are minor differences, you can argue the case is on point. I would say if there are major differences, you're not going to have it's unlikely that you'll be able to argue that the case is on point. Then what can you argue if the case is not on point? Well, you can try to argue that the legal principles apply, even though the facts are a little different, right? Or a lot different. You can say, Your Honor, I see the facts in my client's case. I see the facts of this other great case. Yeah, they're not all that similar, but look at this legal principle. It ties the both together, and you can make an argument. But just keep an eye here on 12-3. Don't get too lost in the weeds. Even I'm getting lost in the weeds with you guys. Just understand the basic principles, right? The basic ideas, the basic relationship of all of this to precedent and to stare decisis. So let me see if I've got any more post-it notes here. Okay, that is the last one that I've got for chapter 12. And what that means is that we have covered, my goodness, 7 chapters in the past, I don't know, hour maybe? That's a lot of detail. It's a lot of information. My goal here is not to overwhelm you, and it's not to stress you out. That's not helpful. My goal is to help you know how to use your time between now and when you decide to take the test. What's the best way for you to use that time so that you can do as well as you can do on this exam? So I'm hoping that what I shared with you helps you narrow down where to focus. If it were me, I would have like notes for each chapter, right? I would look at chapter 1, I would probably screenshot the exhibits, and I would take notes on the big themes. Same for chapter 2, chapter 3, and so on. So I would have notes for each chapter. Within the notes, I would have either screenshot those exhibits or, somehow highlight them in your book so you can quickly reference them. You will have time to look up things quickly if you're already familiar with them and you just want to confirm. But you won't have time to learn things for the first time. Like you don't have that much time. It's an hour and a half, right? So hour and a half with, roughly 45 questions. The more prepared you are, the better you'll do. The more focused you are, the easier it will be to answer the questions. And know going in that there's a lot of the A and C, B and D, just knowing going in that that's going to be there. And that can sometimes trip you up. So that's why in situations like that, you might want to have your notes out where you can look things up real quick. You guys have been great. You've been so quiet, but I know you're all there. Does anyone have any substantive questions that they want to ask about any of the material that we've covered so far? No? Any administrative type questions other than me making sure that the exam is opened and that you can access it? That's at the top of my list. Other than that,
I have
any?
a question. I'm
Yes,
just
go ahead,
not
Paul.
right. I didn't catch that last part about the answers. You said there'll be A and
Yes.
B and then C and D. Can you
Yes.
explain that a little bit more for me?
Yes, I can definitely do that. So I took the test this morning because I wanted to know how to prepare you guys for it. And typically on a multiple choice, you have 4 answer choices, right? A, B, C, and D. I like those because I can do well on those. Where I get tripped up is where it's A, B, C, D, and E, right? There's more than 4 answer choices. And on each line, it's not an answer choice. It's like let's just say the question is, what's your favorite fruit, right? Let's just say that's the question. A will be apples, B will be bananas, C will be oranges. So on D, it'll say apples and bananas. And maybe on F, it'll say oranges and apples. Does that help you understand, Paula, what it is that I'm getting at?
Yeah.
So you see that's the tricky part. For me, that was the tricky part of the test, is because the question choices weren't just one answer question choices. A lot of the question choices were apples and bananas and, oranges and whatever the other grape or whatever, I forget. And so that's where, if you don't know the details, you can easily get the question where you know the answer, but you get tripped up the way the answers are presented to you. That's the part I really didn't like. And I did not make the test. So if I had made the test, I don't think I would do that so often, which is one of the reasons why I'm going chapter by chapter with you over each chapter to kind of show you and remind you, because so much time has passed, what were the major themes in each chapter and where are the areas you should focus to notice some of the distinctions between things like, for example, mandatory precedent versus persuasive precedent. And what are the areas where there's, it's like, I don't know what the right word is, but it's like you're going to find lots of questions. It's a lot of these where you have like 3-step process or, 4-step process, because it's easy to ask, what's the second step, right? What's the third step? And you won't know that off the top of your head unless you've organized your thoughts and your notes and your exhibits. Then you can just look it up. Boom, I know what they're asking. Boom, I know what they're asking. So having taken the test, I took it cold turkey. I took it closed book. Obviously, I've been with you guys every day since, day one. But I found that part of the test to be challenging. And I thought to myself, well, what can I share with my students so that that is less of a thorn in their side? I think the key is really preparation. And I recommend to do it chapter by chapter. if you have time, go back and look at the case studies we did together. I think those are good questions. You can use those as kind of test questions, right? And even your quiz questions, you can use those as test questions just to test your knowledge. But that's a great question, Paula. I think I may have, sometimes I forget what I covered early on and what I may have covered like 10 minutes in, but I think I don't know at what point I said that. But that's really the thing I think that's going to frustrate you guys is you're going to know the answer, but you're going to be confused by, is it this one and that one? Or this one and that one and that one? Meaning, is it apples, bananas, and grapes? Or is it just apples and grapes? Does that help you, Paula?
Yes, it does. Thank you.
Okay, you're welcome. Let me think, what else can I share with you? So again, organization of your notes is key. Once you've organized your notes and the exhibits, I would then go and test myself with reviewing the case studies to see if you're getting the point. And if you're able to access the quizzes that you took and you know what the right answers are, I would use that to test myself too. I think because there's a limited number of questions a human being can ask from these chapters. So I would suspect that the questions in the midterm are going to be loosely based on the questions we've already talked about, but maybe just more detail. And also just keep in mind, your weekly projects weigh twice as much more than your midterms and final exam. But that doesn't mean you shouldn't do your best. You should, but just keep in mind that you can buffer your grade by doing really well on the weekly projects. That kind of builds in some cushion for you. So I'm looking at this mathematically, and I'm also just looking at this like, how do I minimize your guys' stress that help give you some good information so that you can focus on and spend your time where it's worth it. And I'm going to be available if you have any questions between now and when you take the test. If you want to email me, you want to call me, you have a question, please feel free to do that. I'll be available and I'll check my email. I'll be more vigilant about that because I know you guys are taking this test this week. But the first thing I have to do is open this for you guys. So that's my first priority in the morning is reaching out to the head instructor and finding out what switch do I have to turn on to give you guys access to this. Does anyone else have any substantive questions or anything else that maybe I can clarify for you, that I can go over with you? Anything of that sort? Okay, so I'm getting silence. So I'm going to take that as a clue that you guys are good. It's easy for me to say it's just a midterm, right? That's a silly thing for me to say. Do your best, go in prepared. You'll get the best result will go to those who are well prepared. And then that's not a surprise, right? What a silly thing for me to say, but I'm stating the obvious, right? Just stating the obvious. Kate's laughing her head off at me. I don't know if she's laughing at me or laughing at somebody else. She's just tired. I think it's been a day. So if there aren't any more questions, I want to give you guys a chance just to let all of this sink in, and then let me do my part and figure out how to turn this thing on. And I'll be available if anybody wants to talk about anything between now and, I generally don't check my emails on the weekends, but I might because it's the test. But if you want to talk about anything substantive, Monday through Fridays is a better, I have more availability. So you can just let me know. Sound good? Okay, guys. So I'm going to leave you to it. Next week, we've got stuff to do. I'll figure out what it is and we'll catch up. But I wish you all the best, and I know you'll do well. And we'll talk soon, okay? And I forgot to turn on my camera this whole time. All right. Bye, guys. Bye-bye. Yes, boo-boo. I have to write an email. Hold on. I have to send an email. Hang on. No, 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 you can't go there. You have to stay here. You have to stay there. Hold on. I need you to step down here. Oh my God, I can't type when you keep jumping on the keyboard. Hang on. Yes, sweetie. Hold on. Are you hungry? I have to send an email. Yes, boo boo. Right, let's take a look at chapter 9. Hang on. Hang on. Hold on. I can't work if you keep sitting on the keyboard. Case study, chapter 9. Read the case study and answer the following questions. Shane Jackson was driving his truck home from a friend's house one evening at sundown when a deer leapt into the road in front of him. Shane swerved onto the shoulder to avoid hitting the deer. A car was coming from the opposite direction, and the driver, a man in his late 70s, swerved onto the shoulder on his side of the road. However, the elderly man's car did not stop at the shoulder. Instead, it skidded to a halt on the edge of a steep ravine and teetered there. Shane ran to the car to help the man. Mr. Wimmer get out of his car. Mr. Wimmer, stunned, sat at the side of the road. Shane went back to his truck, backed it up to Mr. Wimmer's car, and was attaching a tow chain when the car toppled over the edge and crashed to the bottom of the ravine. The sound startled Mr. Wimmer out of his shock. He struggled to his feet, looked down at his car, and glared at Shane, and he said, "I'll sue you for that." Shane contacted his attorney. Keisha, the attorney's paralegal, was present during the interview between her supervisory attorney and Mr. Wimmer. Keisha's supervisory attorney asked her to provide him with a summary of the interview. Keisha knows that the summary should highlight the key facts, which are also known as A, background facts, B, irrelevant facts, C, material facts, or D, basic facts. I'm going to say that it's C, material facts. And let's look to see if I'm right. That is correct. The key facts are also known as material facts, meaning the facts that are important to the case. And number 2. Hang on. All right, so number 1 was, let's go back. We have material facts for number 1. Chapter 8. Chapter 8, number 1. Material facts. All right, number 2. Keisha should also list background facts because they put the key facts in context. I believe this is true. Let's see. Oh, somebody's home. Take a peek. Correct. Types of facts in general, background facts, help put the key facts in context. Number 3. Shane is African American and Mr. Wimmer is Caucasian. This is, oh boy, is it a key fact, a material fact, an irrelevant fact, or a background fact? I believe it might be an irrelevant fact, and that is correct. All right, let's go to number 4. As part of the 4-step process for determining key facts, Keisha should first identify each cause of action. That sounds like it would be true. Yes, that would be true. If you know the cause of action, then you know which facts are relevant. Next one. As part of the 4-step process for determining key facts, Keisha should err on the side of listing too many facts in order to identify the key facts. I believe this should be false. Well, as part of the 4-step process for determining key facts, Keisha should err on the side of listing too many facts in order to identify the key facts. Apparently, this is true. Why is this true? Let's look. Okay, key facts identification, client's case. A client's fact situation usually includes a mix of facts, some irrelevant, some background, some key. A researcher's assignment may be to identify the key facts. The four-step process is recommended. All right, Exhibit 9-2. Identification of key facts. Identify each cause of action. Whoops. What did I do? Identify, how do I move this? Each cause of action. Determine, at 9-2, steps and key fact. Step 1, step 2, step 3, step 4. Identify each cause of action, determine the elements of each cause of action. So you need the cause of action, then you need the elements. List all the facts possibly related to each cause of action. Determine which of the client's facts set us. Okay, then we do the final analysis. So filter and facts. All right, so that means that the following is referred to in this section's process as the operation of the four-step process. The researchers assigned the task, make this bigger, whole book. They have lived. Anne wants Jerry to stop spraying the trees. They've been ruined. Identify each cause of action. So identify each cause of action. The first step requires determining the possible causes of action raised by the facts. Depending on the education and legal experience of the researcher, this initial step may not require any research. In the trespass example, upon reviewing the facts, the researcher may come to a preliminary conclusion that the possible causes of action include trespass to land, private nuisance, and negligence. Step 2, determine the elements of each cause of action. Step 2, determine the elements of each cause of action usually requires some research. Some research may be necessary either to determine the elements of the possible cause of action or to ensure that the law has not changed since the last time research was conducted. This step is necessary because to state a claim and thereby obtain relief, the plaintiff must present facts that establish or prove the existence of each element of the cause of action. These facts are the key facts of the case. Step 3, list all facts related to the elements. Third step is to list all the facts possibly relating to the elements of the causes of action. And step 2, this includes gathering the facts from the interview and any other interviews, reviewing the documents. Client file must be checked to make sure it's complete at the initial stages of client interview, maybe all that you have. Err on the side of listing too many facts. Oh my goodness. Err on the side of listing too many facts. You want to have all possibly related facts at hand when you proceed to step 4, the step in which the irrelevant facts are eliminated and the key facts are identified. Determine which facts apply. Fourth step is to determine which of the client's facts apply to establish or satisfy the elements of each cause of action. The facts identified are the key facts. Be sure to consider each fact listed in step 3 and determine if it is essential to establish. Okay, so re-examining the question and the answer choice, now that I've read the 4-step process for determining the key facts, Keisha should err on the side of listing too many facts in order to identify the key facts. This is now true. Check my work. This is correct. Okay. Next one, question 6. After Keisha provided her supervisory attorney with a list of key facts concerning Shane Jackson's interview, during which Shane described the deer that jumped in front of his truck, his helping Mr. Wimmer get out of his car after the encounter with the deer, and the unfortunate descent of Mr. Wimmer's car into the ravine, the attorney asked Keisha to search for cases that have facts similar to Shane's case. The first thing Keisha should do after finding a case is determine the elements of each cause of action, look to the holding, identify each cause of action, read the entire case. The first thing Keisha should do after finding a case that have similar facts to Shane's case is probably look to the holding. Am I wrong? It's wrong. Determine the elements of each cause of action. No. Identify. It's read the entire case. Well, that would make sense. The first thing you should do after finding a case is read the entire case in order to know what you're working with, the facts and the law. Okay, number 7. Keisha needs to keep in mind that sometimes a key fact is not a single fact, but a whole group of facts. True. Correct. Key facts, definitions and types. To identify key facts, Keisha should also look at how the court applied the rule of law to the legal question, which is called the court's holding. Correct. 9. Keisha should not look for key facts in concurring and dissenting opinions. I don't know if that's true. Well, I don't know. False. Keisha should look for key facts in concurring and dissenting opinions. 10. A useful test in determining whether a fact is a key fact is to ask the question, if this fact is changed, would the outcome of the application of the law change? I believe this is true. And that is correct. Okay. Let's look at a quiz. For chapter 9. Gathering and identifying facts depend entirely on the thoroughness and the quality of the pretrial preparation. Gathering and identifying facts depend entirely on the thoroughness and quality of the true. The fact is a combination of two elements, an actual event and the interpretation of the event. I believe that is true. It's false. The fact is a combination of two elements, an actual event and the interpretation of that event. Okay. The rule of law and the facts of a case are equally important in resolving a legal dispute. Maybe. Okay. Whether a court opinion is on point is largely governed by the similarity between the facts of the court opinion and the facts of the client's case. Largely governed by the facts of the court opinion. Facts and the law. I thought it was facts and the law. Okay. In a lawsuit involving a car crash, the day on which the crash occurred would be considered a material fact false. I believe this is false. Correct. Background facts are key facts because they provide information that helps the court understand the overall picture. I believe this is true. Incorrect. Background facts are key facts. They provide information that helps the court understand the overall picture. Okay. The key fact is so essential that if it were changed, the outcome would change. Maybe. Right? In some situations, no individual fact is a key fact. Is that true? Oh, that's true. Okay. Individual facts that seem to be insignificant may be key facts when considered and weighed as a group. I believe that's true. True. Legal professionals typically follow. Good, sure. Hang on. Screen am I on? Screen 3. Oh, I forgot to share. Legal professionals typically follow a basic formula when determining how many or what types of facts should be part of the key group of facts. I don't think so. I think that's false. Key facts are an element of the legal issue. I don't know. True. Key facts are an element of the legal issue. In listing the facts in a case, it is good practice to include only the facts that have a direct bearing on the cause of action. False. If a fact is essential to establishing one of the elements of a client's cause of action, it is considered a key fact. Additional causes of action identified while conducting later research cannot be added. Can amend. Holding is the court's application of the rule of law to the legal question raised by the facts of the case. The facts critical to the outcome of the case are called the key facts. Excellent point. Facts. Key facts. Key facts. Key facts. Identifying the facts that give rise to a legal dispute in either a client's case or court opinion is the duty of the standard established by a governing authority that prescribes or directs action or forbearance is called a the precise question raised by the specific facts of a client's case is called the issue. In every legal case, there are two equally important factors: the law and the facts. Facts that put the key facts in context are called background facts. The two categories of key facts are individual facts and groups of facts. The first step in identifying the key facts in a client's case is fourth and final step in identifying the key facts is the first step in identifying the key facts is to identify the issue, the entire case, look at the holding, and the key facts. The holding, the entire case, the entire case. Well, that makes sense. Mm. That, that, chapter 9. Oh my God. Slides. No. Legal analysis key facts. All key facts must be identified at the outset of the case, usually via a thorough interview. The importance of certain facts may not be identified until the legal issues and governing law are identified. Facts in general, definition, facts of a case, important information present in a case concerning a real thing, action, event, or circumstance, rule of law. A standard established by a governing authority that prescribes or directs actions or forbearance. Types of facts in general, irrelevant facts, background facts, key facts. Key facts. Legally significant facts that raise the legal question of how or whether the law governing the dispute applies. Types of key facts, individual, group. Key facts, identification, client's case. Identify each cause of action, determine the elements of each cause of action, list all the facts related to the elements, determine which facts apply. Reread the entire case, look to the holding, identify the key facts. Okay. And what else is on the syllabus? That was the other one. And that one. So that is going to be, we're supposed to do refresher unit 2. Chapter 4, case law. Research and briefing. Chapter 9, legal analysis, key facts, refresh. Chapter 12, Case Law Analysis is a case on point. Week 9 project, key facts. Week 9 project. 9 checklist. Key facts. Week 9 project, key facts. In preparation for your week 10 assignment, case brief, this assignment will allow you to practice determining what facts are relevant and what facts are irrelevant. For the case, which fact, IRRELE. For the case in Maryland versus Pringle, list each of the facts in the case in a Word doc. For each fact, identify if the fact is relevant background, relevant individual fact, or relevant group fact. You must explain why. Each fact, identify if the fact is relevant background, relevant individual fact, or relevant group fact. You must explain why. Next week, you'll be briefing this case and you will be responsible for including only the relevant facts. This exercise will prepare you. May work in pairs. However, if you do so, each student must still submit their own work. Also, students should identify who they worked with. Okay. We'll have the IRAC. 3 project IRAC. Ended. Edit. Activity.